so lucky to work with you, and she's our legal expert. She's been an attorney since 1980, but we're going to have her, so now we're just going directly into the issue. Hopefully by the end of this, you're going to be able to speak about the ERA independently, right? So thank you, Diane. Here you go.
Who knows everything about the ERA? Raise your hand.
You.
Who knows a lot about the ERA? Raise your hand. All right, a few of you. Who knows nothing about the ERA? So a little bit. So we're somewhere in between with what you know. All right, well, let's start out with, what does it say? What's it say? Who's got it? Did you pick up one of those books back there? What's it say? Somebody read it. It's on our handout. Yeah, read it.
Women shall have equal rights in the United States in every place subject to its jurisdiction.
Nope. That's not what it says.
Equality of rights under the law?
No.
Oh, what?
Oh.
Yeah, that's the,
Read it.
okay, equality
Oh,
of rights.
okay. Keep going.
Okay, but then the second part, okay, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. That's number one thing.
Paragraph 1.
Paragraph 1.
Yeah, paragraph 2 says Congress has the right to make laws about this, and paragraph 3 says it takes effect 2 years. What you were reading is what it said a long time ago, and they changed it. Okay, so that's what it says. Now, one of the problems is, some of you are old enough to remember back in the 80s and when we were fighting for this, and they came out with this, one of their arguments was, well, it's pages and pages and pages and pages of laws, and you'll never understand it, and it'll just change everything, and we don't even know what it says. Well, that was a lie then, it's a lie now. And there's a cute little book back there that Jenny Lee brought that says the full and unabridged ERA, and it's 121 pages, and every page has the same thing on it, because that's all it says. So anyway, when was it first introduced? 1923. When was it passed in Congress? 1972. So in order to pass an amendment, 2/3 of Congress has to pass it out, right? In order for it to get passed. And that did not happen until 1972. How it happened, I learned this when I spoke down in Green Valley, I don't know, a year or so ago. This woman worked in Martha Griffith's office when Martha Griffith, a Republican from Michigan, was voted into Congress. And you know, you go into a new office and you clean out all the files on the desk and everything, and you throw away old stuff, and you're going to put your stuff in there, right? Well, she finds a file folder, and on it, it's written, the label says, broads. Well, what could that mean? So she opened it up, and in it was, guess what? The Equal Rights Amendment. Ticked her off. So she said, all right, I'm going to get this passed. And she did. Not the first year, but the next year. She is the one that got it passed in 1972. So it came out of Congress 49 years after it was introduced, and 2/3 of Congress had to vote for it in order to get it out. So it comes out, and what's the next thing that has to happen in order to become a constitutional amendment?
State ratification.
3/4 of the states have to ratify it. 3/4. That's 38. How many have ratified now?
37.
37. So, when she got it passed in 72, after it was passed out of Congress, Hawaii ratified it in 32 minutes. 32 minutes later, because of the time difference, Hawaii ratified it. And 35 states had ratified it by 1982. And that's when it came to a stop. Some of us remember Phyllis Schlafly. Yes, yes. Funded by whom? She was back then funded by whom?
Eagle Forum.
Yeah, but who funded the Eagle Forum? The Koch brothers.
Oh.
Back then, I did not know this until recently, that's where she got her funding. I didn't know. So, that's why we need that lot of dirty money, yes. If you haven't signed it, sign it. All right, so then we had a hiatus until 2017, when Nevada signed it and then Illinois signed it. So we have one more state necessary to sign it. Now, I'm going to get to the legal issues in just a second, because there are, of course, there's always legal issues, right? any good lawyer can come up with an argument against and for something. All right, so what about Arizona? What happened in Arizona? In 1974, it was introduced for the first time in the Arizona State Legislature by whom?
Sandra Day O'Connor.
Sandra Day. She was not even O'Connor then. She was Sandra Day.
Oh.
It was defeated, and there are lots of stories about that, and some spicy comments that are into the Arizona record, a legislative record after it failed, and the same kind of comments we'd be making today. So it was introduced off and on after that, pretty much every year. Was defeated again in 1979 when it had been introduced by Sister Claire Dunn, the only sitting sister in the United States in the state legislature. She introduced it. So it was not about abortion, was it? Because a Catholic sister would not have been introducing it if it was about abortion, now would she? No. But it failed then as well. So after 1979, it was introduced off and on every year. After 2007, it was introduced every year in Arizona State Legislature, and it was never assigned to a committee ever during all those years. In 2018, 2 Republicans finally signed on, and they were Eugenia Rita and Heather Carter. And in 2019, 5 Republicans signed on. Those 2, plus Kate Brophy McGee, and then Tyler Pace, who took his name off again, and John Fillmore in the House. So we have been increasing the numbers of Republicans every year. And it was finally assigned to committees in 2018, but never heard. In 2019, it was introduced, it was assigned to a committee in the Senate, but never assigned to a committee in the House. So, that is the history of what's happened to the ERA in Arizona. Now, what are the arguments against the equal rights?
You don't need it.
What?
You don't need it.
You don't need it because you already have equal rights, right? Well, number 1, the 14th Amendment does not give women constitutional equality. If it did, why would we have needed the 19th Amendment to vote? Right? Non-lawyers can figure that out. Don't need to be a lawyer. Secondly, the 14th Amendment under legal precedent does not protect us. Antonin Scalia, not a friend of ours, right? But apparently a friend of Ruth Bader Ginsburg, said himself, well, they were friends. Don't ask me how or why, but they were.
Of course.
So he said that the 14th Amendment did not protect women. And if you look at the cases since 1867, you will see that it does not. So back in 1867, women since that time have been suing under the 14th Amendment, shortly after it was passed in 1865, to try to get equal rights, and it hasn't worked yet. Now, how many of you know, y'all know, or how many of you don't know what Brown versus Board of Education is? Everybody knows that case, right? Well, this did not happen overnight. It took many years of the NAACP having a case here where it applied to a law school, and then a case where it applied to college, and then a case where it applied to a high school, and finally a case where it applied to an elementary school. And they kept building and building and building the theory until they got to the point of separate but equal. It's not constitutional. So that's what women started to do, headed by whom? Ruth Bader Ginsburg. Yes, several women, of course, filed lawsuits before she came around, but she got interested in this and founded the ACLU Women's Rights Project. How many of you saw the movie about Ruth Bader Ginsburg? All right. How many of you saw the documentary? Okay, so quite a few of you. So she started working on the same kind of theory that the NAACP had used to build up the cases around the country that would eventually result in women having equality and constitutional rights under the Constitution and the 14th Amendment. Well, it didn't work. I have written a 10-page paper on that, which you can get. I think it's on our website too. And hopefully it's for non-lawyers. Any other lawyers in here? No. Hopefully it's for non-lawyers to be able to understand what's going on. But let me try to explain the rationale. When a case, and this is really the real difference, the real importance of what the Equal Rights Amendment will do. When a case of discrimination goes to a court, they have a structure of analysis to determine how to rule on that case. There are 3 levels of scrutiny: rational relation, intermediate, and strict scrutiny. Starting at the bottom is rational relation. Rational relation means if, now I'm the judge, if the legislature had any reason whatsoever to pass the law they passed, then it'll be okay. So when women started suing in 1867 under the 14th Amendment, it was analyzed under rational relation. So if a court had any reason, if a legislative body had any reason to do what they did, we'll say it's okay. And here's an example. A legislature passed a law that said, and this was, I think, 1879 or something like that, that said women could tend bar only if the bar was owned by their husband or their father. Now, why? If you're the legislature, why would you pass this law? What were you trying to do?
It protects her.
Protect women. Why would that protect women?
Because the husband or other male relative can step in if someone gets saucy.
Yes. If someone gets saucy, you're gonna get a punch in the nose from the husband or the dad, right? That was their theory, exactly. So the women who wanted to be bartenders, sued and said, we want to be bartenders. Now, they didn't have this law apply to the waitresses who walked out to the tables where the guys actually were. The bartender stands behind this long bar. Who's more likely to be assaulted, the waitress or the bartender? Right. The waitress, right? So it wasn't about public safety, it wasn't about protecting women. What was it really about? Money, jobs, exactly. Keeping women out of men's jobs, right? So this, of course, is what the women argued when they went to court. And what did the legislature say? What did the court say? If the legislature had any rational reason, any reason at all, even if it's not the real reason, even if it's not a true reason, and they actually said that, even if it's not true, even if it's not the real reason, if there's any rationality between what you did and what you claim you're trying to resolve, the problem you're trying to fix, it'll be okay. So under that kind of analysis, we're going to lose every time, aren't we? Because you can always come up with some kind of stupid reason about why you wanted to pass a law about this or that, right? So we lost and 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 we lost. 1967 was when intermediate scrutiny came into existence. This was created by a judge. This is judge-made law, so to speak, which is how we do it in the United States. And this was a case, over the years, of course, women had been getting louder and louder and louder about the fact that we didn't have equality. So in 1967, a state passed a law that said girls could drink at 16, drive. Girls could drive at 16 and boys at 18. Now, what would be the reason for that law? Huh?
Neurobiology.
Well, they weren't talking about that at that time. Now, we would say that now, but they wouldn't have said that then. What do you think was the reason?
Girls are more responsible.
Girls are more responsible. Boys are nuts at 16. They're drinking and driving and testosterone and smashing up the cars and everything else, right? And girls mature faster. So they don't smash up the cars so bad. So that was the reason for passing law. That's the reason they gave when they got to court. And the court said, well, is that true? Or is that just a stereotype? they said, we don't know.
The insurance company knows.
Insurance companies claim to know. So the judge said, go get a study done. So they went and they got a study done at the university, whatever it was, and they came back and they found a very small difference. There was a difference, but a small difference, between the amount of crashes and wrecks that the girls had and the boys had. And I did my part. I smashed my car, my dad's car, 3 times. 3 different cars, actually. And he had big cars, Lincoln, so that I wouldn't die when I did this. So the court said, well, that's not a big enough difference for you to have made this, because now we're going to have an intermediate scrutiny. Not only does it have to be some legitimate reason you're passing this law, but you're going to have to prove that what you pass actually will result in the goal that you seek. So you got to prove it. You can't operate on stereotypes. So that began a good step for us, didn't it? Because so much of the laws and the crap that goes around is based on stereotypes as opposed to reality. So that began the step forward of trying to get women equality under the Constitution. With the 1967 intermediate scrutiny. We're still there in intermediate scrutiny. From 1967 to now, we're still there. We're the only ones. Nobody else fits in that category. So I'll come back to that in a minute, but let me go to the highest category of scrutiny. Strict scrutiny. That is reserved for the classes of people who are identified in the Constitution for protection. Who are those people?
Race, religion, national
Race.
origin. Race, religion, national origin.
Race, religion, national origin, condition of previous servitude, and color. In the 14th Amendment, it says, thou shalt not discriminate based on race, color, condition of previous servitude. All of that was for African Americans, right? And national origin was because we also enslaved other people like Chinese and Mexicans and Native American and everything else, right? So that was for them. So those 4 are named in the 14th Amendment, and religion is named in the First Amendment. Those 5 categories of people get strict scrutiny. So whenever a legislature passes a law that negatively impacts any of those groups, the court must look at it with strict scrutiny. Meaning, not only does the legislature have to say, this is a valid legislative interest like public safety or saving taxpayer dollars or some other reason, it also has to really, you have to prove it's going to accomplish what we are aiming for it to accomplish. Why did you have to burden this group of people instead of burdening everybody or nobody? Isn't there some other way you could do this and achieve the same result without burdening one particular segment of society, etc.? So there's like 4 or 5 different hurdles they have to jump over in order to pass a law. So how many times is the state going to win in these cases?
Not often.
Not often. So when you get to strict scrutiny, you win. That's what women tried to do. So we started moving forward in '67. And then Ruth Bader Ginsburg got involved, and cases were brought here and there and there and here and here and there. And we moved forward. And for lawyers, it's very important what the words are. Because every little word in a decision, then you use that in the next decision. Well, it has to be significantly related. Well, it has to be proven beyond a reasonable doubt. Well, it has to be this, it has to be that. So each time we were getting closer and closer and closer. I was in law school at this time, and we really thought this was going to happen, that we were going to get strict scrutiny through the court cases, through the Supreme Court, and then we really didn't have to worry about the ERA. Well, that came to a screaming halt in 1990, I believe it was. Yes, it was 1990, in the Virginia Military Institute case. If you remember the Virginia Military Institute case, this is a state school funded by state dollars in which girls could not go. Well, how is that fair? It's not, is it? So women sued. And they said, no, you cannot spend taxpayer dollars on a state school and not let women into it because they're half of your state, right? Makes sense, right? But, so who wrote the opinion on that case? Ruth Bader Ginsburg, right? She was in the Supreme Court by this time, and she wrote the opinion. So, the problem was, in a section of that opinion, it says, men and women are still different enough that this decision does not give women strict scrutiny under the Constitution. Us lawyers all win. What? Ruth, you fought your whole life for this, and you just sold us down the toilet, right? What happened here? We could not figure out what happened. Well, it took me many years until I finally figured out what happened. Then I only figured it out because I read that book, Sisters-in-Law, about Sandra Day O'Connor and Ruth Bader Ginsburg. It's an excellent book if you haven't read it. Sisters-in-Law. And in there, it explains what happened in this case. She got the opinion assigned to herself, which is what you want to do. When you want to write the opinion, because you want it to say a certain thing and lean a certain way, you get it assigned to yourself to write. So that's what she did. And it was a 5-4 vote. And she was going to put in there that women had strict scrutiny under the Constitution. And when she proposed that first draft of the opinion, she lost some of the justices. And he said, if you put that in there, I'm voting on the other side. You lose. It's 5-4 the other way, and they're going back to rationalization. Think how hard that must have been for her
Oh, yeah.
to do that. But she did it to keep that 5th vote. But that stopped the lawyers' move towards women getting equality through the Supreme Court. And there hasn't been a case since.
Which justice was it?
I don't know. It didn't say, and I think specifically why it didn't say. They didn't want you to go shoot him or something, you know? Probably already did by now, but at any rate.
She's joking.
So that's what happened, and it stopped. And no cases have happened since that time, trying to move us into strict scrutiny. So we cannot get it that way now. It's done. The only way we can get it is through the ERA. Okay, so that is the real big reason for the ERA. Now, when the ERA passes any will we have equality the next day?
No.
Will we have equal pay the next day?
No.
Will domestic violence stop the next day?
No.
Will rape stop the next day?
No.
Or sexual harassment? No. We all know none of these things will end the next day. We all know this is a long process of enforcing the law and bringing the cases and making the public arguments and on and on and on and on. So it's not going to change anything overnight. But this, what I just described to you, is the basis that's going to allow us to win these cases instead of lose these cases. Now, over on the table, there is a handout of 10 reasons, 10 ways an ERA would make a difference. And it talks about different cases that we have lost since then. We lost the Morrison case, where in the Violence Against Women Act, when it was first written, we put in a provision similar to 42 U.S.C. 1983. You know, for African Americans, they get shot in their hometown, and the police will not arrest, the prosecutors will not prosecute, the judges will not find them guilty, and nothing ever happens, right? So what do? They go to the federal court and file a civil rights action. It's not a criminal case, but it's at least some kind of justice for them to what has happened to them, because their state won't do it. So that's in 42 U.S.C. 1983. So we put a provision like that in the Violence Against Women Act. So Morrison tried to, Brunzali, I can't even remember her name now, tried it. She did it. She was raped by a football team at a college campus, and they would do nothing about it. And she went to the city, they would do nothing about it. And she went to the state, and they would do nothing about it. And so she brought an action similar to that in the federal court. And the Supreme Court threw it out and said Congress didn't have any power to make a law that gives women the right to sue in federal court. Because why? Because women are not in the Constitution. So there's an example of how we lose because we're not in the Constitution. The Jessica Gonzalez case in Colorado, anybody remember that one? Domestic violence, husband took the kids for a visit, never brought them back, she went to the police, they wouldn't do anything. The husband then showed up at 3 a.m. in front of the police station, started firing a gun, they came out and shot him, and all the children, 3 children were dead in the car.
Oh my gosh.
We still don't know if he shot them or if the police did, accidentally, because they cremated the bodies before the mother could get them. So that makes you think the police shot them, because why else are they hiding that? She took her case to the Supreme Court against the Colorado Police Department that did this and lost. Because she didn't have any right. Under the
Constitution.
Constitution! She's taken the case to the Inter-American Commission on Human Rights, and of course she won there, but none of that brings her children back. The Betty Duke case in Walmart, you know, there was a class action case against Walmart. They found all across the country that women were being paid less in the same jobs than men. We lost that one too. And we lost it because it says you can't have a class action because Walmart has a policy of individual decision making. They've delegated these decisions to their local staff. So it's not a Walmart policy. It's just individual decision making that is wound up with women always in every state and in every store making less than men, right?
Yeah.
Well, they're not the same judges, but, and well, most of you don't know this, but in a case called Gadulik versus Aiello, I was in law school at the time, and this is when the judges came up with the idiotic example that it was not discrimination. Discrimination against pregnant women was not discrimination based on sex. Because it wasn't between men and women. It was between pregnant persons and non-pregnant others. And some women are not pregnant, right? So therefore, it wasn't between men and women. We sat in our law school classes going, what part of the biology class did these judges miss? But that was the decision, okay? So if you pick up this handout, there's 10 different examples of how we've lost cases since this 1990 case that I told you about, because we are not in the Constitution. So when people say you don't need it, you do. All right, so that's one reason. What's some other of their reasons why we don't need the ARA?
Or why they oppose it, or why they
Why oppose it and why they oppose it.
That women could be drafted.
Oh, women could be drafted. Geez, and women might have to fight in combat positions. Well, women already do fight in any combat positions that they're qualified for, right? There is already been a judge's decision from Texas that said women are going to be drafted next time if there is a draft. Do we have a draft right now?
No.
No, we don't have one. But this judge said, should we have one, you're going to be drafted. And there was a military commission that put their initial report into Congress in January, and they're going to put their final report in March of 2020. And they're tasked with the idea of, well, what are we going to do? You know, should we continue the registration for men? Should we have a draft? Should we register women? What should we do? What should we do? Well, if you read their interim report, which I just read, it's pretty clear. They're going to say that women have to be drafted. So what that means is, we have all the responsibilities, but we don't have all the rights.
Yeah.
And that's the way it is. We have to pay taxes. We should vote, right? And now we're gonna have to serve in the military, but we don't have all the rights. So this is why, another reason why we need it. All right, so what's another
The
opposition?
biggest one that we get is that there was a deadline attached to the ratification process, and the deadline ended, so why should we vote on something that's moot?
Okay, the deadline issue. This is, from a legal point of view, another completely false narrative. In the constitutional amendment, well, all right, let me begin at the beginning. There were no deadlines on any constitutional amendments until the 18th, which was prohibition. They put a 7-year deadline on prohibition because they really didn't want it to pass. And they thought, well, if we put a 7-year deadline on it, it will never get passed. Well, it was passed in about 8 months. We shocked the crap out of that. So then the next amendment was the 19th, which was women's right to vote, right? There was no deadline on that. No deadline was put on that, no timeline. After that, from the 20th up until the 26th, there was a 7-year timeline put on there just out of habit. They just started this habit of this is when we'll at least know it's over with, right? So it was just a habit. So it's not required in the Constitution. If you look at Article 5 of the Constitution, which tells you how you amend the Constitution, it does not require it at all. Secondly, it's in the preface. It's in the preface of the bill that was the ERA, that is the ERA. Any lawyer can tell you that what's in the preface is not law. The preface is an explanatory note to tell you what it's about. It is not law. So it does not have any legal basis. And third, there have been many cases from the Supreme Court, not many, a few actually, about 5, cases from the Supreme Court regarding timelines on other amendments. After the Civil War amendments, which were 13, 14, and 15, right? Slavery, equality, and voting. After they were passed, other states tried to change it and attack them based on a deadline. And also the 18th Amendment, with the Prohibition Amendment, states later, after it was passed, tried to attack it based on the deadline argument, and they failed every time. Because the Supreme Court said, it is not up to the courts to say how to amend the Constitution. That is given specifically and solely to Congress in the Constitution, how to amend it. It's Congress's business. So Congress put the deadline on, Congress can take it off, Congress can say it's passed, even though it's not. And the Director of National Archives, who is a lawyer, has said, in his mind, as far as he's concerned from a legal point of view, when that 38th state is done, it's in. He's putting it in. He's stamping it and putting it in. It's done. So the last thing is Article Amendment 27, which we have passed, was first introduced 202 years before we passed it.
Or we ratified it.
Ratified.
Yeah.
202 years. It was introduced back in the 1790s or something like that. And it says that when you are a sitting senator or representative, you can't raise your own salary. If you raise the salaries of the senators and the representatives, it doesn't go into effect until after the next election, because you might not come back to that seat, right? So you're raising it for the next person to sit in the seat, which might be you, but might not be you. We passed that 202 years after it was introduced. So don't tell me that we have to have a 7-year deadline. Thank you very much, right? So two things on that. There are bills introduced, SJ Res 6 and HJ Res 38, introduced into the House and the Senate to get rid of the timeline. And we're trying to use timeline, not deadline. To get rid of the timeline. So sign those letters, make sure you can leave them, we'll mail them, or you can take them, mail them, whatever you want to do. But we're trying to get those passed. We have 211 people signed on SJ Res 38, which probably will pass soon. Getting it through the Senate is going to be a little more difficult, but that's one thing that's happening. And the lawyers think that we can win this case. I'm sure some nasty people will sue, and we believe we can win this case. Winston & Strawn has volunteered pro bono to do all the legal work for the Equal Rights Amendment. So they're up on it, and we believe we can win this case. So that's another one of the arguments. What's another one of the arguments? Yes?
We're gonna have to rewrite all the laws and it'll be chaos.
Oh, I've never heard that one. That's
Well,
good.
That was said before, and of course it's absolutely untrue. Number one, it gives 2 years before it goes into effect. So that if there are any state laws that are in violation or would be in violation of the Equal Rights Amendment, they have 2 years to fix them. However, back in the 90s, most states, I think maybe all states, I'm not sure it was all states or just most states, had task forces that went through their state laws and changed them all. That's already happened. And the federal laws too. Most of this happened with task forces in the 90s, and it's already done. Now, there might be a few things that you do have to change, and fine. That's a good idea, then we'll change them. Right? But there's a 2-year grace period once it's passed, once it's ratified in the Constitution. There's a 2-year grace period for states to do exactly that, whatever needs to be done. And if you do need to change your laws to guarantee equality for all people, that's a good thing, not a bad thing, right? What are some of the other arguments?
Abortion?
Abortion, 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 and abortion, and abortion. Yes, that one. And my answer to that is, abortion is already a constitutional right under Roe v. Wade. I do not need the Equal Rights Amendment to make abortion a constitutional right. It already is. Now, you've been fighting against it since it was passed. We've been fighting for it since it was passed. We're still fighting, it's at the Supreme Court, it's in the states, it's everywhere, we're gonna continue fighting and that's the end of it. But the ERA does not make abortion a constitutional right. It already is. And it can be regulated. This crap about, oh, you can have abortions the day before you have the baby. I mean, every constitutional amendment, every law can be regulated, every one. Remember, you've all heard you can't shove fire in a theater, crowded theater, right? You have free speech. That does not mean you can say anything you want. We have libel laws, we have defamation laws. You cannot say anything you want. There's sexual harassment, there's bullying. So every single constitutional amendment can be regulated, including the ERA would be regulated like everything else. Like abortion is regulated, like free speech is regulated, like search and seizure is regulated, like cruelty, death penalty, and all that is regulated. And it can be. So that's nonsense. And somebody else said something else.
I don't know how you would answer this one, but there are people who say we are not equal and thus should not be protected under the law as equal.
Well, what can you say to those people? I mean, if you believe that, that's fine.
Repeat what she said, just in case it wasn't heard.
There are some people who say women are not equal, whether it's a church belief or some other belief that they have, that women are not equal and should not be said to be equal under the law. And there's no way to answer that except you're entitled to have your own beliefs, believe whatever you want, but you are not entitled to force those beliefs on everybody else.
I'm gonna speak on that before you go to another topic, because I hear this sometimes. Some people are under the same assumption that we're trying to be the same as men. And so you have to agree that yes, there can be differences, and I want to be equal under the law. I don't want to be a man doesn't want to be me. We don't need to be the same. We just want equal protection.
Well, when you look at the statute, the amendment itself, that's what it says, under the law.
Exactly.
It does not say in your family, it does not say in your church, it does not say in your school, it does not say in the bathroom, it says under the law.
And it doesn't say we all have to be the same.
No, absolutely not. Wait, she was first. I'll come back to you.
Well, what about some of the, like, the transgender and gay whole thing with this?
Well, what about it?
Well, the
Yeah.
fact that people are saying that this makes being transgender okay, and we're giving
Okay.
transgender people their rights, and it's.
Read the Equal Rights Amendment. It says sex. It doesn't say LGBT, transgender, anything else. It says sex. Now, I spoke at a Republican LD, and they brought this up, and they said, with a timeline, and they said, well, you have to start over again because, this 1982 is already passed, blah, blah, blah. I said, well, actually, there has been a bill to start over, and you're gonna like that one less than you like this one. And he said, why? I said, because the start over bill says equality under the law for women and LGBT and trans and elder and everything under the sun, the disability and everything else.
Gender.
And he said, okay, well, never mind. And I said, okay, so pass this one, right? And there's cases in the Supreme Court right now to see whether sex under Title VII, which is a statute, not a constitutional amendment, will be applied to transgender people or not. There are 3 cases at the Supreme Court. They've combined them, so there will be a decision coming out soon. But that is one of the arguments is, I don't want to go to a bathroom where a transgender person has been or is going to be. Well, in the past, back in the 80s, they said, I don't want to go to a bathroom where a man might have been, a strange man that I don't know. And I say, have you never been on an airplane? Because on an airplane, you go into a bathroom where a strange man has been that you don't know, right? I mean, it's just silliness. And regarding today, with the transgender thing, I say, well, you've already been in a bathroom where a transgender person was. You just didn't know it, right? And
you live to tell the
and
tale.
then one woman in Winslow said, well, a man might put on her dress and come in there and attack me. I said, well, if they put on her dress, it's probably easier to fight them off than if they don't put on her dress, right? And she said, well, men go into to bathrooms and assault children. I said, yeah, they do that now. They do that now. So how does this change anything, or how does this help us? Why should you punish us because of their bad behavior? Don't punish us. And you had a question.
I just wanted to comment
Yes, go.
before that I think what could be helpful is to remind people what those rights are under the law, that it's not a cultural statement, but it's like, what are the facts?
Right.
What objectively are we speaking about?
Right. So it's under when the law is applied, whether you can get credit cards. Remember when women couldn't get credit cards on their name?
Yeah.
Some of us can remember that. Or, buying a house. You're too young to remember that, but it's true. Buying a house or getting a job or any of those things. Yes, you had a question?
Oh, well,
You.
okay. Yes, I was lobbying a legislator, state one, a couple years ago, and he was a sports guy. So he said that he didn't want the ERA because, number one, women were gonna have, girls, not women, of course, we're not women, we're girls. So girls would have to be on the football teams and on the same basketball team and athletic teams as the men, and that he was going to have to coach men and women together on the same teams, and that would be impossible.
And this is the problem that you brought up about the difference between same and equal. Now, how do you get on the basketball team? How do you get on?
You try out. You have to
try
have
out.
the skills.
And if you're not good enough, you don't get on, right? That's a funny story. We had 2 basketball teams when I was in law school, and the older ones of us who'd never played basketball in high school because we weren't allowed, we could only play half-court basketball because their wombs would fall out if we ran across the floor. They actually told us that. They actually said your wombs will fall out if you run too much.
That's why you couldn't run marathons.
That's why you couldn't run marathons.
It was a real
Your
reason.
wombs will fall out. Okay, so we never played basketball. And so one team was older ones, I was in that, and we called ourselves the Supreme Court because there were 9 of us. And then the younger ones called themselves the Legal Eagles. And they won every time, of course. And we played the medical school women. They beat us all the time. But we just thought it was pretty funny. It was pretty hysterical. But you don't get on the team if
5 minutes.
you're not good enough, right? So there is one woman who's going to be playing football, right? I mean, just recently I read one woman in some school somewhere, she got a football scholarship. If she has the ability,
She's a kicker.
let her go. No, it was a different one. It wasn't the kicker. Someone else. Let her go. And it's the same with the rest of them. It's based on merit, and it should be based on merit. It should be based on ability. It should not be based on sex, right?
Right.
Then there's also the Title IX part of it too.
What's that?
Well, the giving women the right to compete in sports.
Yeah.
Which was never allowed before. So, I mean, isn't that a part of law that's been established it is a part of law that's been established for decades.
Yes. Right.
So, yeah.
And just one last thing I want to say in the last few minutes I've got is that of the arguments that they give, the only one that I think has any merit is it will destroy the family. Now, every change is set to destroy the family. Same-sex marriage was going to destroy the family, and I used to say, what, your husband's going to run off with the gay man when it's legal, or you're going to run off with the lesbian, which is more likely. And equality was going to destroy the family, and daycare was going to destroy the family, and women working was going to destroy the family, and everything is going to destroy the family, right? What family? If you mean the family where men have all the power and women and children have none, if you mean that the Equal Rights Amendment will destroy that family, I say, good. That's the family we want to destroy. Because everybody is happier when there's equal rights in the family, on the job, in the legislature, in the community, wherever. It helps men as well. It helps children as well. Men have used the title, the 14th Amendment cases more than women have, and they've won more often. So that's really what they're afraid of. That my little mythical family will be destroyed. That family of the 50s never existed. I grew up then. Said family never existed. Okay, my time's up. Any last questions anybody's got to have answered? I'll be around.
I was going to say.
And we're going to have a Q&A at the end.
Right, we'll have a Q&A at the end, but I thought, why don't we, we're going to have lunch.
Yeah.
But we can continue this discussion while we keep asking questions during lunch. We'll keep talking and using this time.
I'm going to stick this in here to chart.
Thank you, Diane.